A very good evening to everyone. I am CA Yamini Gujar, moderator for this webinar, and we are delighted to welcome you all to this webinar, been organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be a moderator in Know Your Law Series 47 webinar on intricacies of Digital Personal Data Protection Act on 25th January 2024 from 4 to 6 p.m. Been organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICAI. In a short while, we are going to start this webinar. And before this, I would like to appraise you about CCLEA and NPO Committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, input to regulator on policy formulation, to develop and publish technical guidance, background material, etc. Also to create awareness for professional opportunities for chartered accountants in commercial law, economic advisory, and NPO cooperatives. Our eminent speaker will talk on the intricacies of Digital Personal Data Protection Act in this webinar, and we hope this would be useful for all the members. We have with us CA Uday Kulkarni sir. He is a practicing chartered accountant with professional experience of 27 years, a fellow member of ICAI. Uday is a certified internal auditor, CIA, and also certified information system auditor. He is also qualified as insolvency professional under the Insolvency and Bankruptcy Code of India. Uday has also completed digital forensic course. Uday is certified data privacy solution engineer. His focus areas are information system audit, cybersecurity, forensic accounting, fraud investigation, IBC advisory, and audit of data privacy. He has a wide experience in the various type of information system audit, external audit, and internal audit, fraud investigation, due diligence. He also appears before NCLT as authorized representative. Apart from this, he is also a national faculty for FFD course of ICAI and a national faculty for concurrent audit course of ICAI. He has also imparted training on various aspects of forensic audit, forensic accounting, and investigation, money laundering, legal aspects, and the cybersecurity in Sri Lanka, Nepal, CA Institute, RBI Academy, National Forensic Science University, SFIO, SBI Credit Risk Academy, NIBM, etc. He is also a member of expert group formed for forensic accounting and investigation standards of ICAI. We welcome you, sir.
Thank you, Yamini. Thank you for your kind introduction. And good evening to all the participants. And wish you all of you a very happy new year. Let me allow to share the screen for today's topic. So Yamini, could you please confirm it's okay and visible?
Sir, it is visible.
Okay, thank you. So today we are going to talk about this latest act, Digital Personal Data Protection Act, that is DPDA, which is enacted in 2023. You can say act which is of a bit kind of an thing. And the objectives of the acts are clearly given in the act itself. But before talking about these objectives which are there in the act itself, we need to understand this. The Digital Personal Data Protection Act or the Digital Privacy Act, these kind of an acts are already enacted in other countries. You might be aware that it started from the European Union, where the GDPR got initiated around 2016-17, and then onwards other countries have also enacted this kind of an acts to protect the digitalized data of any person of that particular country. And they wanted to protect the digitalized data, not only in the country itself, but outside of the country also, the citizens' data needs to be protected. It should not be used for unwanted purposes, and it should be used only for the lawful purposes. That was the need which was enacted by these various acts within the various countries, and the
Yes, sir.
yes.
Yes, sir. Sorry to interrupt. Just I want to confirm to all the participants that if there is any query, you can put your query in the query box and we can take it in the last 15 minutes of this session. Okay. Thank you, sir. You can continue.
Yeah,
Thank you.
okay. So these were the basic purposes in other countries as well. And one more thing was there, that every other country, like India, is also expecting other countries to protect the Indian citizens' personal data in their country. Similarly, the European Union also expected to protect the citizens of the data related to the European Union citizen in India. So reciprocative arrangements are expected in all these acts. And other business related reasons for enactment of this act is that now India is very much in the export of the digitalized services. I mean, lot of BPOs, KPOs kind of an processes or business processes are handled in India, located India, and they are handling the data of the citizens of various countries. So all these countries are expecting that India should also have this data protection act, so that it will reciprocate the things and they will have more confidence while handing over the businesses to the Indian businessmen. And that was the one of the conditions, you can say, in GDPR also, that GDPR wanted to have the similar kind of an ads in the countries where the digitalized services are getting outsourced. So there are various business reasons, as well as there was a basic reason to understand the value of the citizens' personal data. And we, as a general, also, we need to understand what is the value of our individual data, our name, our date of birth, our various identification related numbers, like in India, we call it as an Aadhaar numbers or PAN card numbers, or even our address. Address could be of any type. I mean, it could be the digital address in the form of email address, or our physical address where we reside. So all these are having a lot of value in this digitalized world, because they can be used for the good purposes as well as it can be used for the bad purposes. And to protect the these kind of an data from being used for unlawful purposes, these kind of an acts were the requirement of an hour, because so much of the data is now available on various digital platform. And some of the time we do not understand that when we are exchanging the data for various purposes also on the digital platform, what is the value of our data, what can be done with our data, right? So all these things is also equally important, and every citizen in India, especially the professionals like us, chartered accountants, we also need to understand the value of our own individual personal data, and as well as what is the value of the data which we are gathering from our clients, and how we are going to protect it, what the measures are required to be taken, what are the legal provisions are there. All these things we are going to discuss today. But before this act, whether these conditions were not available or similar kind of provisions were available before the enactment of this act, the answer to that was yes, but it was only one section, Section 43A of the Information Technology Act. It was talking about the protection of the personal data. And the person who is processing the personal data, if they were negligent in handling or processing of any sensitive data in that provision under Section 43A, the requirement was of handling and protecting the sensitive data. And if there would be any negligence on the part of any person who is processing that data, and because of that any person suffers any losses, at that time that particular person was required to pay the compensation. But not much cases were registered under that Section 43A, maybe because of the unawareness of the citizens, unawareness of the general public about that provisions. Otherwise, we are on individual level, on professional level, we are experiencing so much time our individual personalized data is being misused for various purposes, right? And that is the cause. And even now you can think about the how much value of this data is, because the deep fake videos which are now getting circulated on the basis of certain videos which were publicly available of certain well-known celebrities, that is also misuse kind of things of our identity, and making it for unlawful purposes or unwanted purposes. So all these things needs to be taken carefully, handled carefully by in every citizen first, and as a professional also we need to understand the various provisions. So that is the basic purposes behind today's discussion. So let us start with the provisions of this act, what this act tells about the digitalized personal data, how to protect that, what are the provisions, what are the responsibilities, etc. And on that background, as a practicing chartered accountant, what we need to do about this, all this we are going to talk today. So the purpose, as I said, the purpose is mentioned in this act is to right of an individual to protect the personal data. So first, it has allowed as a right, basic right of an individual that he or she does have to protect his personal data. That is a basic right. The second objective, which is mentioned there, that the personal data will be processed only for the lawful purposes, which is allowed for under the various laws, and the purposes which are going to be declared by the person who is going to collect the data, and not for any other purposes. Necessity with the international practices, as I said, that various countries have already adopted this kind of a data protection act, and to reciprocate the same, and to ensure the global world that India is also part of or taking care about the personal digitalized data of every citizen, not only of Indian but other countries as well. To make them sure, this act was enacted. Now, what is the data? Basic thing is that when we are talking about this personal data or digitalized personal data, one has to understand what is the data. So data is defined under this act, and data means a representation of information, facts, concepts, opinion, instruction. So all the channels or all the modes by which data is available on the digitalized platform. So it could be available on in the form of information, it could be available in the form of conceptual nature, or in the form of opinions expressed on various platforms. It could be available by various instruction. So all the modes by which a person can express himself on this digital world, all that things are covered under the data. And further, the data definition says that all this in a manner suitable for communication. The basic thing is all this digital media is used for the communication purpose. Interpretation purposes also it is going to be utilized. Processing, a processing, who will process that? The process could be done by the human beings or by automated means. So it may be possible that whatever the data we are entering into the various digital form on the digital world, on the digital platform. So nowadays, because of the artificial intelligence or the robotic technologies, the processing could be done by the human beings, or it could be done by the automated means. Simple example is that when we visit to various government offices, when we visit to the banks or insurance companies or on their portals, we enter so many details of our personal data, right? It starts from our name, it goes to our professional or employment related details. They may ask about our salary, they may ask about our income levels, they may ask about our the properties which are in our custody. So all these details are very important one, and all those are covered under this the definition of the data. And all these data could be, as I said, we are providing them for obtaining their services. That is a legal manner. That is for the lawful purposes we are providing them. But they should not misuse that. And whatever the purposes they are gathering that data, first they have to declare that we are going to see that provision, and then it could be processed by them, either by their staff as the human beings, or it could be used by them for processing with the various automated channels, or by automated means by using the various digital technology. So the processing whether it is handled again by the human or whether it is going to be handled by any other digital platforms, all that way it is covered as an data. So they have covered almost, I can say, the all the elements of the data. They have covered all the elements by which the processing might have been done for getting the results out of that data. So all these definitions is inclusive kind of and things for that purpose. Now what is digital personal data? So digital personal data means personal data in the digital form, right? So how it could be in the personal data in digital form, and what will happen? So many of the time what will happen, so we may fill up certain forms, right? So let us say that we have to open a customer account in the bank. So what we do first, the bank will ask us to submit details in the printed form, physical paper form, and then they will convert that into the digital form. But that is when they are going to convert that into the digital form, or whether they are going to collect that even on that paper based form, all that becomes a data for them. And for all these two factors, the provisions of these acts are going to be applicable, and we'll see that how it is going to be applicable. What is personal data? Because this act is talking about Digital Personal Data Protection Act, right? So it is more of a personal nature. So what is personal data? So personal data means any data about an individual who is identifiable by or in relation to such a data. So personal data means what? So it is the data by which one can identify Mr. X, one can identify Mrs. Y. So how the person can be identified? What are those elements of the data by which an individual or a person can be identified? So basically, every person is going to be identified by his name or her name. That is the basic thing. Then there could be some numbers like the Aadhaar numbers, like the PANs, by which again the individuals or the person is going to be identified. Sometime it could be possible by a particular address, email address. That is also the way by which one can identify the person individual. So these types of the elements which are attached to the identity of an individual, that is called as in personal data, and the protection of that personal data is the responsibility of the person who is undertaking the processing, who is collecting the data, and who is undertaking the processing of such data. So one has to understand, when we are collecting the data, how much data we are collecting, which could be of the nature of a personal data. So various elements. I mean, if I'm declaring my salary, that could be one of the factor by which one can identify me. So without showing my name, and I am the person exceptionally having, because let's say that certain CEO, they are earning in crores of rupees, right? So the news is going to be published that Mr. X is going to collect the salary of so much of crores of rupees. So even in other days, if one cannot declare the name, but if the digital platform is making available the news like that, one person or one individual is getting the salary of so much and so much crores of rupees, by that way also one can be identified. So the elements could differ, right? And all those elements needs to be taken care about in this personal data. Last year only this act, I am in 2023, not even 1 year has been completed so far after the enactment of this act. So the personal data and its elements that will be get debated over the years. Even the jurisprudence will come forward about this kind of an elements which could be related to this identification mark or not. But whatever general elements we can say those are available right now, those things needs to be taken care about when we are talking about the personal data, right? Now, the third definition which is important, that is data principle. Data principle means the person who is having that data. So my name is Uday Kulkarni, so I'm the data principal, right? So if I'm going to disclose my membership number, that could be identifiable. When I'm going to disclose my PAN, that is my PAN number, that can be identifiable. When I'm going to declare my Aadhaar number or even my PF numbers or any other unique numbers, even my address, email address, or any other things. So for all that data, I am the data principal. I am the data principal to whom that personal data is related to. So data principal means the individual to whom that data, personal data relates to. So all these numbers are related to me, email ID is related to me, name is related to me, location is related to me. So for all this information, I am the data principal, right? So everybody whose data we are collecting, whose name we are collecting, whose address we are collecting, whose date of birth we are collecting, that person is called as a data principal. Now, what will happen if we are going to collect the data of a child or a minor person? So, in that case, the provision says that for the child or for the person who is having certain disability, their lawful guardians are acting as a data principal. So, they are going to take the decision about that data. So, they are the data owner. One way we can say that they are the data owner. I am the data owner for my personal data. Likewise, for the child or for the person with disability, their lawful guardian will be the data owner, and they will be called as a data principal. And the data principals are allowed certain rights under this act. That is the importance of the data principal definition. And the next one concept which we have to understand is the data fiduciary. And this is important one. So what is data fiduciary? So it says that the definition says that it means any person, right? It means any person who alone or in conjunction with other person determines the purpose and means of processing personal data. So what it talks about, data fiduciary. Now, who are the data fiduciary? So banks are asking for so much detailed personal data, right? Personal data. So bank is falling under the category of data fiduciary. Insurance companies are asking the details about the persons when they are going to allow the sanctioning these insurance policies, or even when we as a chartered accountant, when we are going to provide the services, we have to keep the KYC, right? So we have to collect a lot of data of that our client. So for that purpose, the chartered accountant will become the data fiduciary, because we are collecting it. We are deciding the purposes, for what purposes we are collecting the data. We are also deciding how this processing of the personal data is going to be done. So let us say that chartered accountant who is providing the income tax return filing services, right? So he has to collect all the details related to the client, like name, address, PAN number, etc., etc., various types of then incomes, bank account detail, etc. So why he is collecting? So all that data will become the data, personal data of that particular client. That client, if he is collecting the data of Mr. X, then Mr. X will become the data principal, and this particular CA who is providing the services of filing the income tax return, he or she will become the data fiduciary. Because now the chartered accountant knows here what he is going to do with this data. He's collecting that data. He may upload that data. First, he may collect that data in physical paper-based manner. If he is having any kind of a digital manner by which he is collecting data, that is also possible. But what would be the purpose of collection of this data? The purpose of collection of the data, because with this data, the chartered accountant is going to submit the return, and for while submitting the return, either he may be using any of the software, or he is using the utilities which are provided by the income tax department. On that utility or on that software, he is going to enter all this data, and thereby the data processing will be done and the results will be uploaded to the income tax department. Now, all these are the things that the data fiduciary is carrying out. And for that purpose, we should be now having the idea when we are collecting the various type of data from various clients and what services we are offering to them. and accordingly for what purposes we are going to use that data, all that things needs to be explained to the data principal, and that is, and consent from the client is required under the provisions of this act. I will talk about that in a shortly. So but chartered accountants, now what the chartered accountants needs to understand here, that when they are collecting the details of the data from their clients, so they have to identify that which are those data which could be nature of a personal data. So they can make the list of the elements of the data which may fall under the category of the personal data, because that needs to be protected. Second thing is that whether they themselves are going to process that data, if what for what purposes they are going to process that data. So according to the scope of services which they are offering to their client, they have to determine the purposes. So whether it is for the tax consultancy matter, whether it is for the filing of return matter, whether it is for any other loan proposal matter. So whatever would be the nature of the services, and accordingly how that data is going to be handled, the process. Sometime it may be possible that the process may be outsourced to any other entity. If that is the thing, that also needs to be informed or communicated to the data principal, because all these provisions are there under this act. So there are various responsibilities which are casted upon the data fiduciary. Uh, since we are also going to become a data fiduciary under this DPDA Act, so we have to ensure that when we are going to collect the data, how many processes, write it down, that 1 to 10 processes we are going to do with their personal data, and we are identifying these are the elements of personal data nature which we are going to collect from our clients. So these things we have to keep in mind when we are collecting the data as a data fiduciary. So as I said, these are the examples. So when we are going to collect the data, we are going to collect the data as name, address, PAN number, Aadhaar number, mobile number, financial data in the form of accounts in the banks, or salary related details if we are filing the returns of an employed person. And our purposes for that should be very clear, and what processes we are going to do with that, whether the processes are internally we are going to handle, or processes we are going to outsource, and the results of the processes to whom we are going to communicate. So as far as the accounting services could be there, it may be possible that the accounting services result, the financial statements, we are going to submit it back to the client. We are not going to upload it on any other site. But perhaps for the taxation matters, for the GST matters, for other matters, the data may be going to be uploaded with the taxation authorities. So all these things needs to be crystal clear and documented, and that needs to be communicated, and the consent needs to be obtained from our client. That is what is, in a short way, the provisions of this act. Okay. Now, as I said, we ourselves can process the data, or sometimes the data processing might be outsourced. So they have introduced the concept of a data processor. So who is the data processor? Means any person who processes personal data on behalf of a data fiduciary. Right. So suppose when we are going to apply for a ATM card, credit card to the bank. So the card is not generated itself by the bank. So what they will do when we submit our request to them to make this card available to us, they process the data with the outsourced vendor. So some vendors would be there who is collecting this data. They will print all the details of the card. They will make this card available to the bank, and bank is going to hand over to it. So when we are requesting the bank to make this facility available, the bank will submit all our personal data to that card vendor, right? But nowadays these things were not shared with the client, shared with the bank customer. Now, because of the provisions under this act, now this kind of an processing which the banks are undertaking, now they have to declare, they have to communicate to the customer that okay, we are going to collect your data, but if you want these services, we are going to hand over, we are going to communicate this collected data to the third party processor, and there should be a consent from your side, right? Similarly, as a chartered accountant, if we are processing all the data in house, then there would be no worry. As a data fiduciary, we are also become the data processor. But suppose we are handing over certain data which we are collected suppose one service vendor is there who is processing that data digitally in their particular software, or it might be possible that the data might be residing in a cloud way and they may be processing the data. It may be also, I mean, everyone will have a different arrangement. Accordingly, we have to ensure that whether we are processing in-house, whether it is going to be stored in the cloud and the cloud vendor is going to process that data. So all these things we have to now understand. Not only we have to understand, we need to communicate and we need to obtain the consent from the data principal. In our case, that would be the client or our customer, right? So that includes, so data fiduciary along with the data processor, both are handling the personal data that which we have to. Now what is data processing? Right, that what the data, what is going to happen when one will collect the personal data? Obviously there would be some processing that will be carried out on that data. So which are those activities which are covered as a part of the data processing, that is also defined in this act. So what is the data processing? It means wholly or partly automated operations or set of operations performed on a digital personal data. So what will happen? The data may be collected in a paper-based manner, that will be get entered in a particular software, right? Once it is getting entered into any software, that becomes the digital personal data. So, but when the process starts, the process starts from its collection. So if you see the second bullet point under this definition, it starts from the collection. So even one person who is merely collecting the data on any physical paper, that collection, that that process will be get covered as a part of the digital data processing, since it is started as a collection, because data processing includes operation such as collection, then the recording. Once we collect on the paper based form, then we are recording, we are organizing, perhaps then it could be organized in a particular fashion as per the software requirement, as per the purpose requirement, structuring, and that data going to be stored somewhere. Even the storage, that's why I mentioned in the earlier slide that storage could be in-house, storage could be in a cloud-based manner. So where we are going to store the data, that is also a part of the data processing. Adaption, then retrieval, use, alignment, combination, sharing, disclosure by transmission, dissemination. So all the methods or all the modes by which data is processed in the real world. Right now also we are using this. I mean, these things are not new in a way that the data is going to be handled. But what is going to happen that now it is defined in in this act. Otherwise also we are doing this, all these processes. Okay, it is not like that. Because of that we are going to use that these processes. When we are collecting the data, we are collecting in a paper based manner, we are recording it, we are organizing it in a better manner. So this is data related to the GST client, this is the data related to the income tax client, this is for the audit purposes, right? So we are doing that. I mean, there is nothing new in this. We are storing that. The storage could be internally arranged or storage could be external, right? So all these processes, in a way, we are right now also in practice, we are using this. So there is nothing new as far as the data processing is concerned. Only thing now we have to take care is that how many of the part we are doing in-house, how much of that we are doing with the external vendors. We can say that is outsourced processing, and they are equally responsible. So we have to ensure the data protection at their end also, because ultimately we are responsible as a data fiduciary. But when we are saying that ultimately as a data fiduciary we are responsible to our data principal, same way we have to ensure that, because for that vendor we are the client, so we have to take care that to whom we are outsourcing this data processing, they are equally capable to protect the personal data whatever we are going to share with them, right? Now, what is the personal data breach? So what is the crime in this? What is the offense in this? So personal data breach means any unauthorized processing of personal data. That is the biggest, you can say, the compromise with the personal data. I will give certain examples of that. So personal data breach means any unauthorized processing of a personal data, or accidental disclosure, acquisition, sharing, use, alteration, destruction, loss of access to the personal data, and because of that, that it will compromise the confidentiality, integrity, or availability of the personal data. So let us take an example. We are visiting one shopkeeper. Let's say it is a medical shopkeeper. Where we are going to purchase the medicine. Now, when we are purchasing the medicine, the shopkeeper asks us the patient name, right? And they enter the patient name. They also enter sometimes the doctor name. They also take our mobile number. Sometimes they also ask about the email ID. So when they are asking about the personal name, they are asking about the mobile number, email IDs. Now they have to declare that what is the purpose of collection of this data? Why they are asking my name? Why they are asking the doctor's name? Why they are asking my mobile number? Why they are asking my email ID? They have to declare. They have to take consent. So they may say that okay, we have to keep the record and we have to keep the record for the billing purposes. So what is the purpose they are declaring here? The purpose they have declared, that is billing purpose. And we are giving going to give the consent. Okay, for the billing purpose, now I have given a consent, right? So that is a legal one, that is authorized one. So I have given the consent. They can take my data, they can record that data in a digital platform, and they can use it only for the billing purposes. But the moment they will start communicating me or advertising me on my email or on my mobile number, that could be the unauthorized processing of personal data. Or if that medical shopkeeper will transfer this data, share this data with any other company by disclosing that these are the medicines which are person and these medicines are related to this kind of a disease. And this is what is happening right now. If you look, when you are searching on a Google or why to Google or any other search engine, when you are searching for anything, you will find that the next time you will get lot of advertisement related to your search. So when you are searching, let us say for a flight from Pune to Jaipur, right? So the next time, whenever you will go to that search engine, they will start flashing all the details about the flight schedules and all these things as an advertisement on your browser. How this is happening? Because these are the things I'm not supposed to get that advertisement. When I'm browsing, my intention is only to know the schedule of the flight. My intention was not there to get or receive any advertisement on my browser by these people. But these things are happening, and even not don't think about the personal data that will be in the name of the in the form of name or in the form of your mobile number, even your IP addresses, right, by which you are just now connected with your IP addresses. All these are also a part of your personal data. And when this personal data protection act will really be get enacted, even the browsers, they will have to take consent about what kind of cookies they are sending to us. When somebody is sending us information, or when we are opening certain websites, we have also, you are also right now experiencing that when you are opening certain websites, you have to give consent by accepting their cookies or accepting their privacy policies. We are not reading that. That is unfortunate sin, but actually we need to read the terms and conditions, because now it is mandatory. Even under this Data Protection Act or under the GDPR, it is mandatory that before obtaining the consent, all the terms and conditions related to the use of that data. So when I'm connecting to a particular website, my IP is getting identified by them, right? So by that identification, how they are going to use that IP addresses, what will they do with that? And that's why they say that accept all cookies, deny the cookies. These are our privacy terms and conditions. We need to understand which are those conditions. What will happen when I will give the consent to all the cookies, right? Because then they are going to personalize our all these experience, and they may send advertisement. These are the conditions which might have been mentioned in your terms and conditions, and when we are going to give the consent, that could be one of the reasons by which we are getting all these advertisement. So before giving consent, by accepting all the cookies, we need to understand the consequences of that. That they may capture all our details, they may capture all our whatever we are searching on that particular site, and they may use that particular searching as a personal data which could be identifiable to you through your IP addresses, and they may start sending the messages, or they may start sending the advertisement on your browser because they have already taken the consent by accepting all the cookies. So we should be very careful about what action we are going to take, because the consent is available in any form. It could be in a written manner, or it could be in a digital manner. That also I am going to talk about. The options are available under this Data Protection Act, but we many of the times we are not that much aware about by reading or going in a detail the terms and conditions which are mentioned for the acceptance. But as I said, in case of a medical shopkeeper, when the medical shopkeeper is asking for my data and the purpose is only limited for the billing purposes, then that medical shopkeeper should not use the data for sharing it to any other company, through which my disease could be get identifiable. And by that way, some company, some doctor, some hospital may try to advertise me for that disease or for any other purposes. So if that is going to happen, then that could be the compromise of the data confidentiality. Now, to whom this act is applicable? So act is applicable, of course, within the territory of India, to whoever, any person who is collecting that data in the digital form, in the non-digital form. That's what I said. In the first initial stages, it could be in the paper-based form and then digitalized subsequently. So that is also possible. And many of the time this is happening. When we are availing the various services, first they are obtaining in a paper-based form, and then they are going to record that in a digital platform. So by whatever mode you are going to collect the data, and if you are within the territory of India, the act is applicable. It is also applicable to the outside of the country, territory of India, if that other company, the foreign company, is using the data of Indian citizen. So let's say that data of Indian citizen is going to be used by an US company, right? So in that case, what will happen? The US company has also getting covered under this act, and they also have to protect this data of the personal digital personal data of an Indian citizen. And these are the provisions. As I said, these are equivalent provisions are there in other acts also. So when we are offering services to the person of European Union in through located in India, we also have to protect their digitalized personal data. So equivalent provisions are there under this act also. So if US company, UK company, any other company is collecting our data, digital personal data, they also are going to be covered, because they have also required to protect the data by the provisions which are available or made through this act, right? So applicability within India and outside India as far as the our citizens' data is concerned. Now, to whom this is not applicable, right? For what data this the provisions of this act is not applicable? Personal data processed by an individual for any personal or domestic purpose. So suppose my data I am handing over to my relatives. My data I am handing over to my friends. Right. It is not for any commercial purposes. It is not for any business purposes. It is only on a person to person basis. Because of my friend relationship, because of my relationship with that other person, I am handing over that data. So for that particular purposes, the provisions of this act is not applicable. Otherwise, it will be too much difficult. तो मैं अगर मेरे relatives को data कोई handle करता हूँ, जैसे मैं मेरे relatives को नाम देता हूँ, मेरा number देता हूँ, मेरे email ID देता हूँ. So in that case, if I am going that, I am offering that on a personal basis, then the provisions of these acts are not applicable, right? Personal data that is made or caused to be made publicly available. And to whom, who will do this? By the data principal to whom just such personal data relates, or by any other person who is under the obligation under any law for the time being in force in India to make that data publicized. So how to understand that? So if suppose I'm writing the blog, right, on the digital platform, and there I'm mentioning all my details, my name I'm mentioning, my contact numbers I'm mentioning, my communication address I'm fully by myself. So that is the data which I'm making publicly available. So on various social media platforms, we are making our personal data available by our wish. Then that data will be public.
Yeah, good evening, everyone. Due to network issues, I got disconnected. He will join within 5 minutes. Thank you.
Yeah, I'm very sorry that because of the internet disconnection, there was a disturbance. I hope now it is again okay. So, yeah, is it okay now? The PPTs are visible? Yeah. I will keep because of the weak internet, I will keep it off. Yeah. So I was talking about the non-applicability of the provisions of this act. So in two scenarios, the provisions of these acts would not be applicable when we are sharing the data on a person-to-person basis, not for the business or commercial purposes. And second thing, we are publicizing our data publicly on various social media platforms or various digital channels by our wish. So in that case, the data is available publicly, and when in such a case, the provisions of these acts are not applicable. So we are going to use that publicly available data for the purposes, but the provisions of these acts are not going to be applicable. So we now discussed the basic concepts. Now we have to understand what are the obligations of the data fiduciary, right? So in our case, the chartered accountants are going to be act as a data fiduciary. So what are their obligations as a data fiduciary? So use of data for lawful purposes. Of course, when we are going to collect the data, we are going to use it for only the services which we are providing to our clients with the consent for legitimate purpose. So we are going to now take a consent. Now this consent procedure is needs to be implemented in our offices. So when you can obtain that consent in a physical form, or we can have the digitalized process for obtaining the consent. Those who are having a huge number of clients, for them, the consent process, I will suggest beneficial could be in the form of digitalized form rather than a physical form. But anyway, we have to obtain the consent from our client as a data principal, that what is the purpose for which we are going to collect the data, how we are going to handle this data, process the data, whether this data is going to be handled within the our services, within our offices, or we are going to outsource to any other agency. All that disclosure needs to be made to our client or to our customer, and we have to obtain the consent. Consent shall be accompanied or preceded by notice given by the data fiduciary to the data principal. Now, right now also, when these provisions were not there, so we have collected a lot of data, right? Right now also, we are having number of clients. We have collected so much of the data. To them also, now we have to send a notice and we have to obtain the consent therefrom. So for all the existing customers also, it is not necessary to give the notices, and we have to obtain the consent from them. What needs to be mentioned in the notices? So in that notice, we have to mention that the personal data and purpose for which the same is proposed to be processed. Right, that's the things which I am repeating again and again. The manner in which she may exercise her rights under subsection 4 of section. So what are the rights are available to her? So different rights are made available to the data principal: right to correct, right to erase, right to get the information. So all these rights are now available under the various provisions of this act. So what are the various rights which are available to her? The manner in which the data principal may make a complaint to the board in such manner, and they may be prescribed. So the data protection board is now going to be set up, and that would be the authority to whom any compromise, any breach of the provisions of this act needs to be communicated to, and how to make the complaint to the board. Right now, that rules and regulations are yet to be formalized, so clear format is not really available. But whenever it will be made available, these things would be available through the rules and regulations, and the board may have yet to be set up. So the mode by which the complaints could be made to that board, all that mechanism will be well known to us, but we should be prepared for that when we are obtaining the consent, when we are communicating with the client. All this mode by which they can make a complaint, all this way, what are the various rights which are available to them, those needs to be mentioned in that notices, and then we have to obtain the consent of that particular processes or for that personal data which we are going to handle. So as I said, consent is very important part of all these provisions. So whatever we are going to do with that personal data of our client, or any not only the chartered accountants, but by any entity or by any profession or by any businesses, when they are obtaining the personal data, it is mandatory for them now that they have to obtain the consent by that data principal, right? The consent, as I said, consent could be in a digitalized form or consent could be in a physical form. So when we on the website, when we browse something and when we accept all the cookies, by accepting all the cookies, we are giving the consent to that. And that consent is getting recorded at the back end. So after that, we cannot claim that we are not given any consent. That will not work out. So either on electronic way or digital way or by the physical way, that consent mechanism has to be now set up by every person who is handling this personal data. And the consent should be specific, right? So if suppose we are providing 10 services, right now the client has approached only for one services. Now, after a time gap, the client has approached for the second or third services. So each time we have to give that particular, we have to obtain the consent from that client that, okay, for these purposes, we have collected the data. For the second services, we may be satisfied with the already data given to us, or we may require additional data. And then again, consent for that newer services may be required to be obtained, because the as the services may be going to be increased, the processing part would be differ, and when we are going to differ with the processing part, it sometimes it may be in-house, sometimes again it could be outsourced, we don't know. So at each level, for what services we are going to provide and what processes we are going to do with that particular data, that we should have a clear idea, and so as we have to obtain the consent from the data principal, that is our client. It should be informed one. As I said, what needs to be informed, that has already mentioned in the provisions. As I said, we are expecting some rules, regulations from the data protection board also, the manner in which the notices may be sent, that particular format may be made available. But right now, whatever we are observing in other countries, when they are obtaining the consent, most of them are obtaining through the digitalized mode on the website itself, by accepting the cookies, by accepting the terms and conditions. Now, reading the terms and condition is the responsibility of that data principal. So they have to give the consent by reading all those conditions, right? Perhaps it may be possible that within that condition, they may ask the consent to share the data with any other person for the advertisement purposes. And because of that consent, the advertisement is getting flashed. So now for that purpose, the data principal is responsible, right? So consent needs to be specific, informed, unconditional, unambiguous, with a clear affirmative action. Right. and it shall signify an agreement to the processing of our personal data for the specified purposes. So when I'm offering my data only for the billing purposes, I'm not expecting any advertisement out of that data communication. So if tomorrow I'm going to get the advertisement from that data communication, that would be the compromise with my personal data. And right now, if you observe, that when we are handing over so much of the personal data to various entities on various digital platform without understanding how and what they are going to use with that data. Many of the times I give the example that we ourselves need to understand the value of our personal data, because otherwise there are even the cyber threats by misusing our data, and that is what is coming in front of us in the form of the fake videos, right? By making the profile in our names by various social by various cyber fraudsters. How this is happening? Because we are sharing our data on unwanted, platforms, by without understanding the consequences of sharing our data. So in a way, this act is going to make aware to various individuals the value and to understand the value of our personal data. Right, because this data is also going to be sold, because when we are unknowingly sharing that data, it may be happening that our data, personal data is going to be sold to the fraudsters. They may going to misuse even our photos when we are publishing our various photos, personal photos on various social media platforms. How is the fraudsters are taking advantage of that data? One has to understand. Photo is my personal data, right? My personal video, if I'm shooting and I'm making publicizing on any digital platform, that is my personal data. But now in front of us, we are understanding the other side of that, the black side of that, that the fraudsters are using that data for unwanted purposes. And none other than the person who is sharing all these things, he himself is responsible for these things, because they are not understanding the other side by which it could be used by the fraudsters. Many of the times it is possible that we are sharing the data with certain organization for certain specific programs. It could be the social programs. But subsequently, what is happening? That organization is sharing their data with their sponsors, with their other parties, and they are flashing the advertisement to us. And this we are experiencing. We are getting various calls on our mobile phones. We are getting various calls on. We are getting various emails, advertisement related emails. We can say that 50% of our email box is covered with such an unwanted mails, which are of the nature of advertisement, which are of the nature of giving the business or professional related services or products. How one can get the idea, or how one can get my mobile number, how one can get my email ID when I am not communicated to organization. So the persons or the organization or the entities to whom I have shared the data, they are sharing those data without my consent to such organization, and they are starting using that by advertising me through the phone calls or through my emails. That is the misuse of my personal data, and that needs to be stopped. So the consent, that should be pre and specific. So as I said, it should be pre, because otherwise you may not charge for that. You cannot keep any condition for that. That is also there. So if you are not giving the consent, the services may not be available. That could be one of the circumstances that is going to come up out of this. And that should be specific. The purposes for which we are going to collect, that should be very, very specific. And all that needs to be covered under this consent. So consent and the responsibilities, or the responsibilities of the data fiduciary as well as the data processor, these two things are very essentially be important. Consent manager means a person registered with the board, so that data protection board, who acts as a single point contact to enable a data principal to give, manage, review, withdraw, or consent. So what will happen? Suppose I might be given a consent to you, let's say for the income tax return filing purposes. Right. So I have given that consent as a client of yours. Subsequently, when I will not be your client, I may withdraw that consent. I may withdraw that consent. So not only the submission of the consent, but even the mechanism to withdraw the consent. right? That is also needs to be available with us. So the client will give the consent. At the same time, they should have a right to review that consent. They should have a right to ask the information from the person who is handling that data, that how that data is used, only whether that is used for the specified purposes or not, and they have a right to withdraw that consent. So all these things needs to be done, and that's what I said, that all this I'm giving this submission of the consent, manage the submit, review the submit consent, withdraw the consent. So all these things are only possible through the digital way, and that's why it is suggested that consent management needs to be digitalized, right? And that could be one of the newer business opportunities that may come out of this Data Protection Act. Now, further obligations of the data fiduciary. A data fiduciary may process the personal data of a data principal for the following uses, right? So, as I said, it should be only for the legal purposes, lawful purposes, for the specified purposes. And for that, the data principal, our client, must have given the voluntarily the consent about that, right? And we should not use the data for which the consent we have not obtained. A data fiduciary may engage, appoint, use, or otherwise a data processor to process the personal data. But for that purpose, this information needs to be given. Consent for that also needs to be obtained. And we should have a valid contract that the data processor should also be under the obligation about protecting the personal data. He will also, that particular processor will also not share the data with any other third party without the consent. A data fiduciary shall protect the personal data in its possession or under its control, including in respect of any processing undertaken by it or on its behalf by the data processor, by taking reasonable security safeguards to prevent the personal data breach. This is very important. This obligation of the data fiduciary is very important. Now, what this obligation talks about, the data fiduciary shall protect the personal data in its possession. So let us say that the client has given the consent. We have obtained all the consent. We know what purposes for which we are going to use that data, but how we are going to store that data and what security mechanism we are adopted so that that data will not, because of any accident, is going to hand over or going to share with some unwanted persons. So our practices, where we are going to store that data, how we are handling that data. In many offices, we notice that the data is transferred with the staff or with the article students by USBs, by emails of their personal emails. And further, what will happen to their data which we are shared on the personal emails of our staff? What will happen the data which we are going to transfer or share through the USBs, because USB may not be under our control, right? So data is going to share with that particular staff. The staff is leaving our organization, staff is leaving our offices, he's resigning from our offices. Still, all the clients' data which we have shared through the email, which we have shared with the USB, would be on the email or in the USB of that staff. So that is a risk. That is a risk. Even in our offices where we are storing the data, whether we are storing it centrally, whether we are storing it on a particular desktop, whether it is shared across all the desktop, whether access controls are not strictly applied for protection of that particular data. So all that mechanism needs to be reviewed by the chartered accountants, right? So storing of the data, access to the data, I may suggest that data should not be available on any personal email. It should be on an official email, and the official email needs to be disabled when the particular staff is leaving the organization. Yeah, the data need not be in any case be shared in the USB form, because we don't have any control on that USB. So all our practices needs to be reviewed upon by when we are looking at the security of the data, the security of the client's data, right? So storing of the data, access to the data, and handing over of data for the work purposes to our staff. Many of the times we observe that the staff is going to get the access to the control by their own devices and by connecting to our central server through the internet. It may not be under the VPN. So there could be the security threats when we are getting connected through the public net. So all these conditions, all these circumstances, now the chartered accountants has to understand when we are going to act as a data fiduciary, right? Now, so protection of the personal data. In a short, what we have to understood by this provision that we are responsible for the security of the client's data, and we have to ensure that because of our lapses, the data should not be get shared or transmitted to the unwanted persons, and even it is going to be shared with our staff. Again, we should have a control that after that staff is going to resign, after that staff is leaving the organization, he or she should not carry any of our clients' data. That is the thing which we have to ensure about. Now, the next obligation that in the event of a personal data breach, the data fiduciary shall give the board and each affected data principal intimation of such breach. Again, the rules and regulations and the format and this, perhaps the website, all that not yet set up. But what will happen? Unfortunately, if such data is going to be get leaked because of accidental reasons or any other unwanted reason, immediately the data fiduciary has to intimate that to the data protection board, and also immediately it needs to be informed to the client that such things have happened, right? A data fiduciary shall, unless retention is necessary for compliance with the law for the time being in force, erase the personal data when upon that data principal withdrawing her consent or as a general obligation of a data fiduciary. Right. Now, again, I will come back to my original example. I have given the data only for the billing purposes. Now that purpose is done with. So unless and until it may be possible that bill is required for the GST purposes or for any other purposes, and there could be obligation that that particular record needs to be kept for 5 years or 8 years as per that particular legal things. But once that purpose is done with, now that data should not be no more with that particular shopkeeper. So let's say that after 5 years, my data should not be with that particular shopkeeper. He or she should have to erase that data. In certain cases, it may be possible that data is not necessary under any of the law. Right. So where there is no legal enforcement to keep the data for certain periodicity of the time, then upon serving the purpose, immediately the data needs to be erased. Because the data principal is now going to enjoy the right to erase the personal data. Right. So all these things, I'm not going to each and every individual. One more thing is that the data fiduciary shall, before processing any personal data of a child or a person with disability who has legal, obtain a variable consent of the parent of a child. So suppose we are filing we are dealing with any of the minors data. So we have to take care that we have to take the consent of their, I think that I have already mentioned in the earlier slides, but we have to take the consent of their parents or the legal guard. Now, under the data fiduciary, there could be one class that could be known as a significant data fiduciary. This is again a provision under this act. So, who are the significant data fiduciary? So, it will be declared by the data protection board. So, they could be the entities who is handling huge volumes of sensitive personal data, right? And there is a risk to rights of the data principal. So obviously, I'm expecting that the chartered accountants are not going to be covered under this significant data fiduciary category. Mostly the banks, insurance companies, financial institutions, government offices, all those are having handling the huge volumes of the data. They may be treated or they may be classified as a significant data fiduciary, right? So these banks or financial institutions who are handling the voluminous data, there could be certain agencies who is handling the data, and that may have potential impact on the sovereignty and integrity of the data of the India. So the PAN mechanism, the Aadhaar mechanism, the electrical democracy where we are getting the voting cards, that kind of a data. So all that organizations that may be classified as a significant data fiduciary. Of course, that is my expectation that the chartered accountants, they may not fall under this category, but the banks, financial institutions, insurance companies, all of them may fall under this significant data fiduciary. What are the additional obligations on on this significant data fiduciary? That they have to appoint a data protection officer who should be the contact person for the complaints to be handled. So it is a grievance redressal mechanism. For that purpose, the data protection officer should be there. And one more opportunity we can say that this significant data fiduciary, they have to do the audit, that they have followed the provisions, they have met the compliance with the provisions of this act. So it is the requirement of that the independent audit, data audit needs to be clarified so as to ensure that whatever be the provisions under these acts, they are complied with. Again, the rules and regulations will shortly come out about this audit frequency, coverage of the audit, what would be the criteria, qualification, etc., etc. And a data fiduciary shall implement appropriate technical or organizational measures to ensure the effective observance of the provision. Now, what needs to be done for the compliances of these things? Consent is one part. But the protection, as I said, even I was talking about the data storage of our client, there are also some technical, the encryption related measures, decryption related measures needs to be adopted. And that is a huge change which is going to be faced by this banking or other sectors, right? Because now encryption, when we are talking that data needs to be encrypted for the security purposes, even that encryption, because the applications through which the data is going to be used, that application needs to be supported for that kind of an encryption and decryption technologies. And it should be available at the relevant person at the appropriate timing for providing the services. So all that is going to be very challenging one. There are various techniques, technologies which are going to be used for the purposes of this protection of the data. That could be another chapter to be discussed with. But these significant data fiduciary, they don't have any choice but to adopt for some encryption or decryption kind of a mechanism, so that the appropriate data will be get protected. Data will not be known to the unwanted person, and only relevant person for the relevant purposes, the data will get accessed to that particular person. So all these provisions technically needs to be also looked into when we are going to say that independent data audit needs to be carried out. Now, what would be the rights of the data principal? So as I said, various rights are now available under these acts to our clients, to the customers. So what could be the rights? The first right is to ask the information. So right to ask the information about handling of the personal data. So they can ask about for what purposes I have given the consent, and only for that purpose the data is used or not. So if they are asking the information, we have to provide that information because that is now identified as a right to that data principle. Apart from that, uh, suppose we have to share the data. Suppose we have taken the consent, we have shared the data to the data processor. So all that data processor, how he is handling that personal data, that also needs to be shared, right? To whom we have shared that data, that also needs to be disclosed. Suppose it may be possible that we have shared the data with more than one entities in the banking sector or in the financial sector. That is possible because many of the activities are outsourced. So when bank is collecting the customer data, it is going to be processed in-house. At the same time, it is going to be used by the switch vendors. It is going to be used by the card processors. It may be possible that the Aadhaar number shared with the banks are going to be used by the various agencies for the payment purposes. So all that the persons to whom that data is shared, that also needs to be informed to the customer or to the data principal. The data principal have additional right to correct the data. Many of the time when we submit the data, it is going to be recorded in the digital form in an incorrect way. Most of the time, we observe that our name, spelling, our birth date, or even our addresses are not correctly recorded. It may be possible that we might not have given in a correct fashion in that particular paper-based form. But anyway, now there is a right to correct is given under this Data Protection Act. So we can go back to the person to the data fiduciary. We can request them that okay, we have given this kind of a spell, but you have entered these wrong things. Now it is there. Earlier there was only that was only the request. Earlier also that mechanism was there, but it was a request. But now it is a legal right given to the data principal that now it is a legal right to correct the data. If the spelling is mistakenly recorded incorrectly in the digital platform, now it is legal right. He can go and request to the data protection officer or otherwise any other mechanism that this is the spelling mistake. Now you have to correct that. Now it is not only the request, but it is a legal right. Right to complete, update, and erase the personal data. So whenever there is a change, there could be the change in the email IDs, there could be the change in my personal address, there could be change in my personal mobile numbers. So whenever we are going to change that details, it is now right. Earlier it was a request, now it is a legal right to update that data. And to update, now this is only not a right. Please understand the intricacies into that. This is not only the right, but the mechanism should be made available. So when right now also you must be observing that through the internet banking, through the mobile app, or by any other digital manner, the banks or the financial institution, they are giving the customers the choice or the mode by which they can correct the data, they can update the data. Of course, they are verifying that with the various mechanism by sending the OTPs, by verifying through the Aadhaar number connected with the mobiles, etc., etc. So there are different mechanisms, right? But now the choice has to be given digitally also, because mostly otherwise it is going to be complicated to handle. If we are having only handful customers, very few number of customers, we can do that manually. But if we are having huge number of customers or clientele, then it is none other than our website needs to be equipped with to handle this, the right to correct, the right to update, and right to complete the details of a personal data. So all these things are now needs to be met. And one more right is there, that is right to erase the personal data. So when the purpose is served and when there is no legal obligation, now as a client, I can say that now that is not a request. Again, that is a right. So I can ask that organization, now my data is no more required for any purposes with you. So please erase that data. Please erase that data. What is the erase? That could be get deleted. That could be no more available to anyone. Of course, the legal provisions will supersede because in India there are various acts, and under these acts, the data needs to be protected for a number of years. Under the PML, it is for 5 years. Under other acts, it could be 8 to 10 years for taxation purposes or for either other purposes. But suppose my client is leaving, now client is no more accessing my services, and after that the periodicity of that much years is completed. So he can again request, and we have to take care that the personal data will be get erased, and subsequent to that, the data will not be made available to anyone. And suppose that mechanism is not adopted, and unfortunately the data is got shared with somebody else, then the data fiduciary is responsible for that. So all these things are now legally incorporated as a provisions under this act. Earlier, it was only in the form of request. So breach of any of these rights could attract the penalties under this act. So data principal shall have the right to have a readily available means of grievance redressal. So again, a mechanism needs to be set to whom that particular client or customer will be contacted in case of a data breach which he is going to observe. So that again, we may not fall under the category of significant data fiduciary, but still the kind of a data protection officer, a contact person should be there to with whom that data principal, I mean client, will communicate about any breaches. And right now, don't think that who is going to use these rights because of the social media awareness, because these things are getting circulated vastly on the digital platform. Once these provisions are, right now it is enacted as an act, but when the data protection board and all these rules and regulations will be there, you will find many challenges and you will find many court cases also, because now the awareness time is very, you can say very small. पहले बहुत दिन लग जाते थे कि भाई कोई एक्ट आ गया है and then the provisions are like that. But because of now the social media awareness, all these provisions will be gets widespread with this social media, and because of that, everyone has to be very cautious to take note about this sensitive issue of the personal data. A data principal shall now. This is one more interesting thing. We have never seen this is happening, but now this is very interesting right that is given to the data principal. What is that right? A data principal shall have the right to nominate in such manner as may be prescribed any other individual who shall, in the event of death or incapacity of the data principal, exercise the rights of the data principal. So far, we have heard about the nomination in banking sector, in the insurance sector, or in the financial sector. Right. So we appoint one nominee to whom that particular amount will be get released after the death. In case of a bank, I'm just giving an example of a bank, right? Or in case of an insurance policy, the nominee will get the amount of that insurance policy. The same concept has now been applied under this act as a data protection, that how to deal with my personal data after the death. So for that purpose, the data principal can appoint a nominee. So one more thing which we have to ask for, that in case of an death, who will deal with the data, personal data, and that person who will be nominated by the data principal, he or she will take the decision about the consent, withdraw the consent, correct the consent, update the consent. Now they will, that nominee will enjoy the right to erase the personal data. So how to deal with that, the data of a dead person, that will be decided by that particular nominee. And the way we are obtaining the nomination in financial sector, the same way the persons who are handling the data, they will have to ask about this nomination facility. That person will handle the data, personal data after the date of that particular person. So this is very interesting, very new thing that is come up with these things. Now, there are certain exemptions to which again the provisions are not going to directly going to be applicable. So if the personal data which is going to be used for enforcing any legal right or claim. So any legal proceedings, if the personal data is going to be used, there the provisions of these acts are not going to be applicable. So processing of personal data by the court, by the tribunal, or any other body which is interested with the by the law for the performance of judicial, non-judicial, so all that things for which the personal data is going to be used. So income tax authority, when we are going to deal with the client data by the income tax authorities, so income tax authorities are doing their things as per their law. So for them, this act is not going to be applicable. Personal data is processed in the interest of prevention, detection, investigation, or prosecution of any offenses. So when the police, the CBI, or any other investigating agencies, they are going to handle the personal data during their investigation process. So in that case also, the provisions of these acts are not going to be applicable. Personal data of data principal not within the territory of India is processed pursuant to the contract entered with that person outside the territory of India by any other person. Right. So it is going to handle like that. The data principal who is not within the territory, he is not an Indian citizen, or he may be Indian citizen but not within the territory of India, is processed. So somebody is in the US and pursuant to the contract entered with the US agency, the data is going to be handled. For that purpose, the provisions of these acts are not going to be applicable. we are going to see the services in the form of mergers, amalgamations, or the restructuring kind of an arrangement. In that cases, it may be possible that two or more companies are going to hand over various personal data. It may be of their suppliers, clients, shareholders, etc., etc. That is the reconstruction. So in the process of reconstruction, the data is going to be exchanged. So when these schemes are going to be formalized, or in that scheme, when the data is going to be processed, the provisions of these acts are not applicable. Now, the last one is very important. The processing is for the purpose of ascertaining the financial information and assets and liabilities of any person who has defaulted in payment due on account of loans and advances taken from a financial institution. Right? So suppose we have taken a loan from the bank, the account has classified as a NPA, and for that purpose, for that particular defaulter's purpose, if any personal data is going to be ascertained, it could be his financial information, it could be his assets and liabilities, by whatever, because there are various acts under which this information is required. So in that case, when the borrower is defaulted, in that case, to take the legal actions or to collect the money, to recover the amount, various actions are now available under the various laws. And in that cases, the disclosure of the personal data is necessary. Right? Even the list of the willful defaulters needs to be published on a particular repository of the RBI website. So in that case, whatever the actions are taken by these financial institutions, and within that actions, whatever the personal data which is going to be handled, the provision for that handling or processing of the personal data, the provisions of these acts are not applicable. So these are some of the we all know that for the legal purposes anyway, the provisions may not going to be applicable. But interesting point is that when the default would be there in repayment of the loans and advances, that is something very interesting that has been brought under the exemption category of this Digital Personal Data Protection Act, right? Yeah, this is a special provision. I may not. Now, let us come to the data protection. So, as I said, under the provisions of this act, the central government may set up this body, Data Protection Act, who is going to handle all the complaints related to this compromise or data breaches kind of things, right? So, what needs to be done, how the intimation needs to be given, right? And the inquiries will be done. Then there will be the how what are the responsibilities of the consent manager in relation to this data protection board, because when there will be the data breach or compromise, the data fiduciary has to intimate to this data protection board. So all these rights and responsibilities has been given to this data protection board. Well, because let us say that when we are going to intimate to this board that particular data breach has happened, so after receipt of this intimation about this personal data breach, then they may require to take an urgent remedial or mitigation measures in such kind of a data breach. If it is a masquerading kind of an effect, if that is going to be had, then the data protection board may suggest that what urgent remedies needs or mitigations measures needs to be taken by these things. Then as I said, this data fiduciary and the data protection officer, they have to be responsible to inform to this data protection board about these compliances as well as any compromise with these things. So all these rights and responsibility, yet all this mechanism yet to be set, and once it will be done, more and more information will be available about this the mechanism and the particular roles to be communicated in form of the communication to this data protection board. The board is also having the right to adjudicate the matter. So they have a right to, penalize a particular organization or a particular person who is processing that data. The penalties are huge in amount, right? But while deciding the amount of monetary penalty, they have to consider certain elements, and that elements are mentioned here is that means what is the nature, gravity, and duration of the breach. what is the type and nature of the personal data which is affected by this data breach, how many times this data breach has been occurring, whether it is first time, whether it is frequently happening, whether it is the data breach is related to one person or it is going to have a mass effect on number of persons, right? And what was the nature of the personal data which is going to be affected by certain breach? Whether the person as a result of breach has realized any gain or avoided any losses. So by sharing of the data, let us take an example. I have not taken the consent about sharing of the data with particular agency, but I have shared that data without the consent, and while sharing that data, I have earned some money. Right. So by that data breach, because these are the things right now happening. So organizations are collecting data and literally they are selling that data for certain amounts. So by thereby they are gaining certain monetary benefits. So without obtaining the consent, if now I'm transferring data, I'm now sharing the data with the companies and they started advertising, that may be compromise of the data, but the agency which has shared the data, they have gained because they have obtained certain considerations. So that will be also taken into the consideration. Whether the person took any action to mitigate the effects and consequences of the breach and the timeline. So they will also consider, okay, this has happened, but what the actions subsequently the particular person who is handling that data they have taken, their security things will obviously be under the scanner. When this litigation will start, the security measures adopted by the person who is handling that data, they will get explored, and that needs to be protected, whether all the technologies were used for the protection of that data or not, that needs to be taken into the consideration, and accordingly the monetary penalty will be imposed. So these are the things, basically the security measures, the consent management, the intimation about the breach, and the mass scale effect about that data breach. All these factors are very important while deciding the penalties by this data protection board, right? So now let us come to the last point. So what would be the really impact on the chartered accountants? Because we are providing various services. We are providing accounting services. We are providing audit services. We are providing the taxation services. So in the audit services, what is happening? We are not directly collecting any of the data of any person as a personal data. Right. But there may be possibility that we are getting, so we are going to handle various datas during the course of the audit. We are going to collect, we are going to process, we are going to identify some samples, we are going to verify those samples, we are going to inquire about those samples, right? Let us say that data's confirmation. So there could be possibility that the data could be the individual ones. And for confirmation purposes, we need their mobile numbers, we need their contact details, right? So that needs to be get shared by the company where we are going, where we are doing the audit. So auditing company will share all this data. Now, first that audit company has to obtain the consent from that data if it is individual, that we are going to share this data for these legal purposes for the audit services, and the auditors may use that data for communication with you. So that consent needs to be there. So when we are ensuring when we are collecting data, same things could be for the any other loans and advances to the staff to which that has been given. So possibly we may have to identify that staff, we may have to communicate with that staff, we have to take the confirmation either on a digital manner or on a physical manner. So all that data needs to be made available by that particular audit team. But the auditee should have obtained the consent about the sharing of such data. As far as the chartered accountants as auditors are concerned, when we are suppose preserving certain personal data out of the audit in our working papers, I think that needs to be looked into 2 points, whether we are going to cover as a data processor, for that consent might have been obtained. And second thing, when we are collecting such data, now it becomes our responsibility to protect that data by various technological modes so that data breach should not happen from our end. So NDA will now play a lot of big role in this case. Even the auditors will have to sign that NDA, even though the code of ethics of the chartered accountants that already says about the confidentiality of the information, whatever we have gathered. But in addition to that, because of the provisions of this act, the companies might take the additional steps to sign in for the NDAs and the data protection measures. Accordingly, we have to ensure that whatever the data we are collecting from the client, we are protecting it, because various staffs or various audit teams are going to collect that data. So coordination about the data collection and the storing of that particular data with the security measures so that it should not be get compromised. That could be the additional responsibility which the chartered accountants has to observe as an audit services. As far as the accounting services are concerned, we may come under the category of the data fiduciary as well as the data process. So why it is coming as a data fiduciary? Because the client with whom we are handling, we are going to collect all the details of that particular client. In addition to that, we are going to process the data of their supplier, their customers, right? So that data would be also available in the accounting services with us. So for that purposes, we are going to process the accounting services or accounting mechanism on that particular data of the client of our client. So we may come under the data processor category. So data processor is again equally responsible to protect, because again for that purposes the client may ask us to sign the NDA and all the mechanism to protect the data needs to be complied with by the charter. For the taxation services, obviously taxation services are very individualistic one. So first thing, our role is of a data fiduciary as well as a data processor. If we are handling that data in-house, suppose we are handing that data to other agencies, then we have to enter into the NDA clauses or NDA contracts with that particular outsourced agencies, and we have to observe that they are making the compliances of this data security. And when for this accounting services, for the taxation services, the consent of the client's client and consent of our client is very important. So consent management is going to be a crucial part in all these things. So what are the steps which are expected? So we should have the digital personal data processing policy. First, we should identify which are those personal data which are we are going to collect. What are the personal elements into that? We have to understand the specific purposes for which that data is going to be processed. We have to obtain the consent by sending the notice even for the existing customers, and we have to ensure that data is only used for that particular purposes. We are not going to share that data by any chance to any other agencies or any other person. Technical measures, technological things, as I said, our data access arrangement, data storage arrangement needs to be relooked. I have already told that not to share the data on the personal email, not to share the data through the USB. When the staff is leaving our organization, the precaution is to be taken about the data in his or her custody, right? Personal data retention periodicity we have to observe. If that is only for a specific purpose where there is no legal requirement to store the data for a particular periodicity, then we have to ensure that we are erasing the data. Right now, we may, as I said, we may not fall under the category of significant data fiduciary, but still the person who can handle the complaints of our customers, of our client, that needs to be understood, and accordingly the person could be appointed. Data audit, that could be an opportunity. Of course, the qualification criteria yet to be decided, but data audit could be an opportunity. We can explore that opportunity. And impact assessment. So we have to assess that if we are collecting so much of the data, what would be the impact if that could be compromised or accidentally get disclosed to the third parties, and for which we are not obtained the consent, what could be the impact? Impact needs to be considered, taken into the consideration the penalty provisions which are there. Of course, I have not disclosed here the penalty provision because anyway, that is not the intention that these are the amounts and this could be the impact. But we ourselves should be very aware about what could be the impact, and accordingly we have to adopt the mechanism for that. So that's all from my side as far as this data protection related provisions are there. So yes, Kanchan, now I'm very much open
Yeah.
for the questions.
Yeah, thank you so much, sir. It is really informative session. So we have received some questions from members. One question has been asked by Mahesh Keni ji. Insurance companies are sending new insurance plans repetitively to individuals since they had collected the personal email IDs. Is it a breach of personal data by insurance companies that they have mail IDs and they are using it?
Now the thing is that after the enactment of this Data Protection Act that has come 2023, as I said, yet the rules and regulation yet to be formalized. But before that, when they have obtained all this personal data, they might have obtained your consent to terms and condition. Many of the times, what happens, we do not read the terms and condition. So probably when you have given the consent, you might have given the consent where you have accepted that they will send you the messages, alerts, or SMSs for their new product. So if you are given the consent without reading that, because of that, they might have been giving you the advertisement. But one thing is sure now, because of the protection under these acts, so you can now withdraw the consent for that particular advertisement. So you can write to them and you can withdraw your consent for that particular advertisement purpose. That is possible.
Okay, sir. Thank you, sir. And one another question has been asked by Bharat ji. What are the difference between Information Technology Act and this act, and also the scope covered by these two acts? What is the difference between that, sir?
Yeah, Information Technology Act deals mainly with the various technical aspects, including the digital, you can say, crimes, right? This act is specifically dedicated to the personal data protection in a digitalized form. As I said, under the Information Technology Act, earlier there was one section, Section 43A. Now that is get repealed because of the enactment of this act. Under that provision also, there was a requirement by the persons who are collecting that particular data to protect the personal data and not to be disclosed unwantedly. And if unwantedly it is disclosed, then the person, they can ask for the compensation. That was a provision under Section 43A. So that was a specific provision for the protection of a personal data under Information Technology Act. Now, this act is dedicatedly only for the protection of personal data. Information Technology Act deals with various other technological things and also with the digital crimes. So digital crimes are not covered under this Data Protection Act. Whatever the compromises and breaches that will happen to the personal data, that is covered under this Data Protection Act. So you can say that they have sliced out the personal data things out of that Information Technology Act, and the specified act has been notified for that purpose.
Okay, sir. So another question is from K.S. Sampath Kumar. What steps are taken by state and central government to assist and protect data security concerns of individuals?
So they have done with this first thing, the act has been enacted. You can say that is because of so many unwanted things which are happening with the personal data that is we are observing. There was an international requirement also that I have also discussed. Now they are going to set up this data protection board. So data protection board is going to play a very important role in all this implementation, because in any case, in any person will have any complaint about these breaches, as there was one such thing which was initially you questioned. So if these things are repeatedly going to happen and even after your request these things are not going to be stopped, then you can make a complaint to this data protection board, and they will now take actions. Not only actions, they do have a right to impose the monetary penalties on such agencies. So that things the government is taking care about through this act.
Okay, sir. Thank you, sir. And again, one question is coming from Rahul S. Kanjivalal. Websites, apps, etc. have been asking for consent by way of acceptance of cookies. However,
Hmm.
there are no information on how a data principal may withdraw or modify the consent at a later stage. How does this act empower the data principal to do that, and have any mechanism been made for submitting a complaint to any competent authority?
Yes, of course. So when we are giving the consent, as I said, we just give the consent by not reading the terms and condition, because with the consent, on the right or left side of that, they mention that okay, you can accept these cookies by going through the terms and condition. So along with the cookies, they many of the times, not it is many of the times, almost all the times, because even though website is handled in India, outside India. So as I said, various countries are now having their Personal Protection Act. So all these website owners now, they have to mandatorily disclose all the terms and conditions. Only thing is that we only concentrate only acceptance of all the cookies. But beside that, along with that, you may find one option where you can find the rights, I mean terms and condition. Under terms and condition now, it is required to be mentioned that how you can withdraw the consent. But unfortunately, we are not reading that. We are not clicking on that rights and condition because there are so many, and we are not going into the depth of that. And without reading that, we just give the consent, and that's how these problems we are facing. But my request is that before going to give the consent, go through each and every terms and condition, look into that. They have to mention about how to withdraw the consent from this acceptance of the cookies. All that mechanism they have to set in that details. So we have to read that details, and through that we can withdraw the consent or give the further consent, whatever the choice of ours is.
Okay, sir. And so last question is whether data fiduciaries such as banks, insurance companies are required to obtain consent from individuals for data collected before the act comes into existence.
Yes, of course. Now, since this act is enacted, it is now mandatory for all these financial institutions as a data fiduciary. So, for the existing customers who were the customers before the enactment of this act, immediately they have to send the notices. They have to follow all the provisions, as I said, notices with the details, the purposes for which the data has already obtained, how they are going to use, whether that is going to be handed over to the third party processes or not. So all that details they have to send to the notices, and they have to obtain the consent from all the existing customers as well. Not only the banks and financial institutions, but even the chartered accountant in practice, they will have to do this exercise of for the existing customers.
Okay, sir. Thank you so much, sir. And is there any other question? If anybody wants to ask, they can send in chat box. So that's all. These are the only questions we received. And now, sir, on behalf of ICI and CLA and NPO committee, ICI Kanchan Vidhani, would like to express my sincere gratitude and thank the speaker, C. Uday Kulkarni ji, for giving their precious time and effort to enlighten us on the topic intricacies of Digital Protection, Personal Data and Protection Act. So your knowledge and experience and your ability to present the subject in such an interesting way made the session very interactive and interesting. We are very grateful for your time and effort, sir. Thank you so much, sir, for the
Thank you,
session.
thank you,
Thank you,
thank
sir.
you, thank you.
And thank you, participants, for joining us. Thank you so much, everyone.